Hey Outbosses, Rhodes Perry here, and boy, do I have a very, very exciting recording for you all to enjoy. It is of a panel discussion that I moderated earlier this year in February, focused on how we can better understand the upcoming U.S. Supreme Court's decision on Title VII and its definition of sex, and how that will impact the fate of LGBTQ plus workers. So the panel discussion was titled, Let's Talk About Sex, and honestly, who doesn't want to talk about sex? So what we were able to cover together was understanding the current protections for LGBTQ plus workers state by state. We learned a little bit around why Title VII matters and how this pending decision may impact how it's interpreted and how it may impact us as a community. We gained some strategies on how businesses, small businesses like yours and mine, can communicate a message of inclusion during this important moment in human and civil rights history. And what was always great about these in-person engagements that I so crave right now is that we were able to build community in person. So that being said, while we can't build community in person, after you give this episode a listen, I encourage you to save the date for Friday at 2:30 p.m. Pacific. Like most Fridays during COVID-19, we are opening up our office hours so that you and so many of us can come together and support each other, to bear witness to just talking about how we're doing, dream up how we're pivoting our businesses and how we might be disrupting our own industries to continue to thrive and make positive changes in the world through the businesses that we own and run. So if that sounds exciting to you, I hope to see you on Friday at 2:30 p.m. And for now, please enjoy this episode. All right. Hey, everyone, and welcome. You are here to talk about sex. So that's what we're talking about tonight, obviously in the legal context. So we have an amazing, amazing panel of just powerhouses here in Portland. And really what we're going to do tonight is just talk about the Supreme Court and the pending decision that we're expecting sometime in the spring. Specifically, where do LGBTQ workers fit in, if they do, in Title VII of the Civil Rights Act of 1964. And so we're going to dive into, what does this mean? Why does it matter? And then in the context of our businesses, so if we're business owners, what can we do more of in the state of Oregon, which is a great state that we'll learn more about in terms of legal protections? And for regional employers, what more could big regional employers do as well? So what I'm going to do is allow each of our panelists just to briefly introduce themselves by sharing their name, their pronoun, just like a little bit about what you do. And then how does the topic personally impact you, if you want to share any words about that. And I just realized that I didn't introduce myself. So other than I'm the board secretary at PABA, I am also a small business owner in the area. And I have a podcast called The Out Entrepreneur. So we're also recording this for that show as well, just to do some education for LGBT business owners about what this means for us and what more we could be doing. Personally, it impacts me. I'm trans, I'm bisexual. I grew up in Florida, which is a state that doesn't really have a whole lot of protections for LGBTQ folks. And there's many other states we'll learn about that don't as well. And potentially the good that this decision could do for those states, as well as if it's not such a great decision, what that means. So with that, and I would just remind our panelists, the mics are off, so just go ahead and turn them on when you're ready to talk.
Okay, hi. I'm Gloria Traynor, and I am a solo practitioner. I'm a lawyer here in Portland. My law firm is just called by my last name, Traynor Law PC. And I practice all civil litigation, and my law firm serves the LGBTQ community. And so my practice areas are personal injury and family law and employment discrimination. I use the pronouns she, her, and hers. And this topic is personally important to me because it's personally impacts my life as a lesbian. I'm married to a woman, but also it's a part of the legal system and the law that I'm really interested in. And I also own my business, and so it's important to me that I stay fresh on these concepts and offer a very safe and inclusive place for people to work. And at this point, I only have one employee, but never know when you might grow, and I want to be able to provide a service to others as well in the context of having conversation about these topics.
Hello, my name is Lake Paraguay, and I'm a lawyer as well. I've been a lawyer in Portland for over 20 years, and I have handled several important civil rights cases in the state of Oregon. One of my most special cases was representing the person who obtained the first legal status as non-binary in the United States. and then that made the New York Times, and someone called me from California, and then they were granted a non-binary recognition in a court. And once that happened, and a lot of the money and organizational power of California, once that started to move, then it kind of happened all over the country. And so now in Oregon, if you're a kindergartner signing up for classes, you get to choose your gender, and on the form itself, there's a third gender. That's unique, I think, maybe in the country, although I think California has that now as well. I also initiated the case that brought marriage equality to Oregon, but those are unique. I mean, on a day-to-day basis, I do divorces and car crash cases, and I advise small businesses, and I definitely have represented the LGBTQ plus community in Oregon for 20 years before, when there was still gay newspapers and there were only gay attorneys advertising in those newspapers. And then everyone realized we were a niche market and we got more equality. So why does this personally impact me? Well, we live in Oregon. We have a lot of state protections that this federal question that we're going to talk about wouldn't necessarily impact directly. But I suppose it affects me because I have friends that live in places where they are not equal citizens and where they can be fired because someone perceives that they don't conform to gender stereotypes. And so that's important. And also, I think it impacts me because I'm here now to talk about it, because a lot of people don't realize what the Supreme Court is doing. So we're going to get to that soon.
Hi there. My name is Nick Rapier. I work for Kaiser Permanente. So I'm sitting here as kind of the employer side in human resources. My pronouns are they and them. And speaking as to why it personally impacts me, being trans has cost me jobs and housing, and being able to work for an employer that both holds itself accountable and actively strives for inclusion and equity has been a life changer for me. So I am very passionate about that.
Thank you all. Definitely a powerhouse panel, right? So we're in good hands for this evening. And Lake, I wanted to start with you first, and we'll just kind of go around and ask some questions. So help us. You have this long track record of both doing divorces in the state, but also helping create, in some ways, some really strong protections for LGBTQ folks. And help us understand, for folks that might be new to Oregon, what are the laws right now for LGBTQ workers? What are our protections, and how? Well, we'll talk about some of the differences in other states, but just starting with Oregon.
So there are some municipal laws. There's a county code and a city code that require that, and then there's state law. And it started, some of these protections for LGBTQ people started in the municipalities, but now it's statewide through what was called the Oregon Equality Act. And that applies to both public and private employers with regard to the way they treat their employees. But it also applies to the way those employees and those businesses treat the public when we're looking at places of public accommodation. So that would be the way that workers, just the employees, were to treat an individual in a bar, or a person of maybe gender ambiguity, if that's even a thing anymore in Oregon. I don't know. I mean, but there still are a lot of binary restrooms, for example. And I recently handled a case where a person used the restroom that was consistent with the way that she perceived herself. And she was actually a biological woman. Like that was what she was assigned at birth. She still considered herself a lesbian. She went into the bathroom, and an employee extricated her from the bathroom. So that is an instance where an employee is violating, arguably, that statute. It's not an employer determination there. But the employer has an obligation to make sure that their employees are not just discriminated against in their employment practices as employees, but that they then don't discriminate wrongly against the public. So we're dealing with sort of both the employer's obligations to the employees and then their obligation to train their employees not to discriminate against members of the public. So with regard to the current legal protections, it is an unlawful practice to discriminate in hiring, firing, advancement, opportunities within the workplace, and also the way in which employees are treated if those determinations are made even in part because of a person's sex, race, religion, and then in Oregon, the language is gender identity or perceived gender identity and or sexual orientation. So it's just it's the perception, it's the words gender identity, sexual orientation are specifically in the law. They weren't always. They were added so that it was very clear that the legislature was specifically wanting to protect gay and lesbian people and gender transitioning or people who have fluid gender from discrimination. It's very clear in Oregon. And that's sort of why we won the gay marriage cases, because all of the law in Oregon over the last 20 years have been incremental steps to very specifically include gay, lesbian, and trans people, and those perceived to be gay, lesbian, or trans within the ambit of civil rights protections.
Thank you. Thank you so much for that, Lake. I think the distinction that you made both for the legal protections and then also the responsibility of employers understanding what that means and doing training to make sure that both they and their staff know how to welcome and include LGBT folks is really key and an important distinction. Obviously, we're in a great state that has very, very strong protections. And Gloria, I was hoping that you could walk us through and help us understand how Oregon compares to other states that might be similar, as well as states like my home state of Florida that isn't as great.
Right, and I moved to Oregon from Texas, so I can probably relate. So as Lake was saying, Oregon labor laws, employment laws are among the strongest in the nation. So they're more protective than federal laws, and that's important to us as Oregonians because I think that we can all appreciate the need or the best practice of going with whatever is the most protective for the LGBTQ community. So I can't really speak to other states specifically, but I can say if you sort of do a broad review of different studies that compare states to each other and how protective employment and labor laws are in those states, Oregon sort of consistently ranks about third to sixth in the nation, and sort of an overall analysis, which includes wage and also right to organize, and then worker protections, which is mostly what we're talking about here. And also, as Lake said, we're here to talk about mostly employment law context, rights and protections, but Oregon has also advanced rights for the LGBTQ community in other contexts. I do a lot of divorce and child custody too, and Oregon was one of the earlier states, both thanks to Lake's initiative, actually legalized same-sex marriage before the federal government, but also in 2007 or 8, I believe 2008, Oregon passed the Oregon Family Fairness Act, which provided that basically every protection that was offered to married couples was offered to same-sex couples by definition in the statute, and really that was pretty progressive at the time. It basically resulted in almost the legalization of same-sex marriage, although we couldn't call it that. So at least in Oregon, so again, the federal government was less protective, but at least in Oregon since 2008, the state has also memorialized equal rights in the domestic relations context. So, as far as stacking up to other states, I think we're sort of at the front of the pack. Lake specifically mentioned that our state's statute includes gender identity and sexual orientation. And there are states that offer protections, for example, based on sexual orientation, but specifically not gender identity. So I would consider Oregon a leader of the pack, particularly in that analysis of protections. Oregon often comes in first. So it's sort of the analysis of all three things together that result in a different result, but it seems like Oregon's really number one in that sense. That does not mean that there's not a lot of work still to be done, but it means we're starting at a good place.
Yeah. And just for context, across the country, if folks are wondering, okay, how does the balance tip? Oregon is one of 22 states, along with the District of Columbia, that has these protections. So that means on the flip, we're talking about 28 states that are silent and are not extending clearly these protections. So, and we'll talk more about what the Supreme Court means in all of this. I do want to give Nick the opportunity from the HR perspective. When we're talking about the power of Oregon, and when it comes from HR, you're thinking about recruiting and retaining and advancing really like the top talent. How does being located in a state like Oregon, as well as an employer that has made these commitments themselves, help you set yourself as an employer apart from others that might not be as much of a champion for LGBT inclusion?
Great question. So I think we're looking at a lot of different things here. So when we talk about Oregon in particular, I also want to include our neighbor to the north, Washington, not just because I live in Vancouver. Washington is also very individual friendly, very progressive. So sort of when we look down the coast, Washington, Oregon, and California, all tend to provide for laws that explicitly include sexual orientation and gender identity in their protections. When we're talking about Kaiser specifically, the company itself is based out of California. And when we talk about a leader in trans protections, California is it. So all of Kaiser's policies are going to be focused from that most inclusive practice. And as a company that has over 250,000 employees and extends to states such as Georgia that does not include protections for individuals for sexual orientation or gender identity, the Kaiser policy is still going to apply both to employees and to members to treat every person who comes through the door with dignity and to give every person a place at that table.
Yeah, that's really powerful when you're thinking about operating in states like Georgia, where really you can be a sanctuary for workers, at least for a third of their life in the workplace, of showing up a little more genuinely in the workplace. So I appreciate that. So in this next section, let's kind of pivot a little bit and talk about the Civil Rights Act, Title VII, and this kind of pending decision within the Supreme Court later this spring. And Lake, Gloria, I don't know who wants to go on this particular question, but would one of you mind talking us through more about helping us understand some of the LGBT specific cases that are before the Supreme Court and how it relates to the sex discrimination provision of Title VII?
Yeah, why don't I start with, and I'll just give you a little bit of a rundown of what who Zarda was, and this is one of the cases before the Supreme Court, right? And this case involved a guy who was a skydiving instructor or accomplice. So you go up in the plane, and then if you're not super experienced, someone has to get tied to your back. And I just did this recently in Malala. It's really, really fun. He was super cute. And but they strap you in, and then they spoon you for the whole thing, and it's great, and you get to go out of the plane. So this guy's up there, and he was attached to a woman, and he said to the woman's boyfriend, "Oh, don't worry, I'm gay," because he was going to be, spooning this guy's girlfriend. And the guy complained about it to the owner, Altitude Express, and this was in New York State, and they fired him. And they brought a case under federal law, arguing under the 1964 Civil Rights Act, saying that when the Civil Rights Act precludes or makes it unlawful to sue someone or to fire someone because of their sex, that necessarily includes sexual orientation. And the argument is that if somebody who is not gay, doing the same job, having the same name, having the same skills, but privately lives a life where he is attracted to a woman, the only difference between the two of them is the sex of their prospective partner. That's it. So it's because of sex. So the petition was filed by a New York skydiving company. At the trial court level, the court determined that yes, the Civil Rights Act does apply because of sex. The only difference here is the sex of the individual, or who the individual wants to be with. So it is within the ambit of the 1964 federal law. It got appealed to the Second Circuit, which is the appellate court of federal questions. The trial court level said, no, it doesn't apply. The Second Circuit said, yes, it does apply. The federal law does apply because it is just the sex that you're looking at. And that's before the Supreme Court now. That question, does the federal law, and again, in Oregon, if you get fired because you're gay, nobody's going to bring a federal court case. We have really good civil rights protections in Multnomah County Court, and there would be no reason to go to this sort of nebulous statute in the federal court. I mean, the federal court's nicer. Like, the courtrooms are bigger, there's no waiting, and you get really, really good, thorough opinions. Right? And we spent $120 million to build that incredible building. It's the emptiest building in Portland, and it takes up an entire block. That's federal power. But in any event, so that's the question with regard to Altitude Express. Does the prohibition on firing people because of their religion, race, or sex include sexual orientation? Of course, on the other side, they're like, no, Congress has had 50 years to make it clear, just like they did in Oregon. If they wanted to include sexual orientation, they could have added that word. And the Equality Act has been before Congress again and again and again. It was before Congress, 20 years ago, but then they wanted to include trans people, and everyone was like, no way! And that could very well be what happens with the Supreme Court. I mean, there's a real reluctance to acknowledge the humanity of trans people.
Yeah, and thank you for that. So before we talk about the possible scenarios of kind of wins, broad wins, limited wins, losses. So there's 3 cases, just for folks that might kind of be following this but aren't following it, and 2 are focused on sexual orientation, being fired from a job because of sexual orientation. 1 is a trans woman being fired from a funeral home. And so I wanted to see if either of you wanted to speak to that as well.
Gloria is going to talk. I just want to say that Mr. Zarda has died. He died young. I don't know if he died in a skydiving accident, but his estate is continuing to pursue this case in his memory and to give him some dignity after death.
So there are a couple more cases that we're going to hear from the Supreme Court about, hopefully soon, I think anytime between now and maybe June. And one of the others is consolidated with the case that Lake just talked about, and that one, I think the last name is pronounced Bozak, but I'm not sure. In any case, Mr. Bozak was a social worker in the Atlanta area that worked with abused and neglected children, and he really loved his job and had been performing there very well. He had the good fortune to be able to report that his agency had served 100% of children in foster care in Metro Atlanta. But in 2013, after he had worked for this agency for quite a while, he joined a gay softball league, and he was fired a few short months later. He lost his livelihood. He lost his medical insurance while he was recovering from prostate cancer. And so the questions in that case are very similar to the ones that Lake just described, which is basically, is sexual orientation protected under the Civil Rights Act because of sex, which is the language in the statute that all of these lawyers are arguing about, and are the few words that these cases really turn on. The other case, the third case, is about a transgender woman named Amy Stevens. And for about 6 years, Amy presented as a man, the gender that she was assigned at birth, at a funeral home where she was a director. But as she began to transition and confirm her gender in other areas of her life, like her personal life and her social life, she became very depressed and despondent about not being able to do the same at work. And the funeral home had some pretty specific and gender-specific dress codes for men and for women. And so Amy Stevens spent a lot of time per her own story thinking about how to inform her employer of her transition, and took about 8 months to write a letter and muster the courage to give it to her employer of 6 years. And she told him that she was going to start living as herself and would be switching from the male dress code to the female dress code at work. And right after she gave this heartfelt letter to her boss, who said he had to think about it, he thought about it for a very short time and then fired her. He made some early statements, the owner of Harris Funeral Home in Michigan, about how his clients were at a very difficult and vulnerable time in their lives, and what would they possibly think if they came to his funeral home and someone who was, as he put it, obviously a man, was dressed as a woman, and how it would be very disturbing to his clientele. I think once he lawyered up, they upped their game a little bit. The Civil Rights Act specifically says that customer preference is not a reason for discrimination, and so that argument fell sort of flat. But Amy Stevens went to the ACLU after she was fired and talked to a lawyer there and told her story, and basically that the lawyers at the ACLU said, these cases can be very difficult. Are you willing to see it all the way through? And I think that's an important part of the story that Amy tells, because often people are really wronged in the employment context on the basis of, because of sex, but, discriminated against for whatever their LGBTQ status is. And it takes a lot of courage to press forward with one of those cases. You get whatever you get from the media. Your personal life is invaded. You will be deposed, and you'll have to give truthful answers in a deposition about the most private parts of your life and possibly the most painful parts of your life. So many people that are discriminated against in these contexts have a really difficult choice to make, to either push forward. Obviously, lawyers need a plaintiff or a complainant to bring these claims and try to change the law, but it really is an enormous sacrifice for the cause, for the plaintiff or the claimant. But Amy told her lawyers that she grew up on a farm and that she was a really tough lady and that she saw everything through to the end, and that's exactly what she's still doing now. So in her case, she went to the EEOC with her ACLU lawyers. They took up that matter, and in the trial court actually found for Amy, but that case was appealed to the Sixth Circuit, which, as Lake explained, is the appeals court of federal question. And in the Sixth Circuit, the funeral home won. And that win for the funeral home was based on the exclusion of gender identity in the words "because of sex" in the Civil Rights Act from 1964, and also based on the religious freedoms of the funeral home director, which is the lesser of the questions I think that we're here to sort of chat about today. And that case is now in front of the Supreme Court. Actually, I'm sorry, I think I have that backwards. I think that actually the trial court found against Amy, the Sixth Circuit found for her, and now the appellant above is the funeral home. In any case, the Civil Rights Act of 1964 that Lake started to tell us about bars discrimination in private and public employment because of sex. And one thing that's important to remember about it that I don't think we've said yet is that it applies to employers with 15 or more full or part-time employees. So the tiniest of employers should, and of course, in my opinion, should still follow and assume all of these protections, but they're not obligated to do so by law.
So this has been super helpful just to understand 3 really, really different cases, right? And so when we're thinking about win, like what does winning mean? Like what is the broadest sense of a win at the Supreme Court? And then sometimes with decisions at the Supreme Court, it feels like a win, but then there's limitations. So could you help us, there's some lawyers in the room, there's some folks who aren't. So just kind of for a lay person, help us kind of understand what is like a win for the LGBT community, and then what might be a win that is kind of like a diet win, I guess.
Well, a win would be Congress specifically identifying gay, lesbian, trans, gender identity, and bringing those within the ambit of their protection very specifically. That would be a true win. The challenge here is that there are conservative justices who look at the text itself when it suits them sometimes. And textually and logically, there is a very strong argument, a rational argument, that it is just because of sex. And I think the RBG movie wasn't it called Because of Sex or something? Really, that's what we're dealing with here, is sex stereotypes. But the congressional intent in 1963, when they were writing this, they were not thinking about transgender people or gay people at all. They couldn't even say those words back then without whispering them. So sometimes from a judge perspective, they're going to be looking at, well, what did Congress intend? But then some judges say it doesn't matter what they intended. You read what's on the page and you perform a logical exercise and you win on the textualism analysis. So it kind of depends on how we win, maybe. I mean, if the Supreme Court, and how many people, I suppose we need a 5-4 to win. There are 9 justices. A win would be if the court said that because of sex means what it says, and logically you can't fire someone because they're gay or transgender, because they're gay or transgender, or even partially because they're gay or transgender. If so doing, I mean, that's what they would say. Like, it would be a violation of the Civil Rights Act of 1964. And then that would mean that all over the land, even in Texas and Mississippi and Florida, that all employers, including Kaiser, and regional medical facilities in Georgia could no longer fire someone solely because they were gay or transgender. That would be a great win. And then sometimes courts also, like Gorsuch, seem to say during oral argument, and all of these were argued at the same time, by the way. They dealt with trans issues. Oh, and then there's this woman she's a Russian scholar. What's her name? She's a Russian reporter, Masha Gessen. She wrote this article in the New Yorker. Look it up. She got her press pass and the information to come to the oral arguments, and there was a gendered dress code. To hear the oral arguments on gendered requirements in places of public accommodation and employment. It's really short. It's really good to read. But Gorsuch seemed to say, it looks like you might be winning on the textual argument. Like, I can see the logic here. But do you really want us to create this enormous social change where everyone's going to freak out and there's going to be mutiny to actually recognize trans people? I mean, do we really want to be addressing a policy consideration that maybe Congress should be addressing? I mean, not really a question that courts, especially conservative courts, ask. They look at the law, they say what the law says, and then they move on. But it appeared to be that he was sort of saying, I don't know, we've given gay people a lot, but we've never really given trans people anything. I don't know if we're going to go there.
Other thoughts on kind of limitations to a win?
Limitations to a win, I have some thoughts, but I was going to interject just a couple of things based on what Lake said. I mean, one of the things Lake is talking about is sort of the difference, and correct me if I'm wrong, but I'm hearing sort of a little bit of discussion about the difference between what some of the people arguing against fighting for these protections are saying, which is that this is judicial lawmaking, that it's inappropriate, that these issues shouldn't be before the justices of the Supreme Court, but rather should be legislated and passed by Congress. Lake mentioned that the Equality Act, Congress has been trying to amend the Equality Act for some years and has tried to add gender identity. And so this is maybe an argument that sex and gender identity are two separate things. And the Violence Against Women's Act in 1994 added gender identity, and some of the opponents of these cases are saying, if that was contemplated and added, then that's different from sex. And so some of those arguments are probably ones to at least think about or consider when we think about, what would a limited win be, what would a full win be. I think there's some of the same things that the justices are probably grappling with. One of the things that's interesting about the oral argument where these cases were argued together is that the justices, they're not the youngest bunch of people. I don't know how woke they are or aren't, But there was a lot of talk about, for example, bathrooms, I think were mentioned. I read somewhere the bathrooms were mentioned like 42 times.
And who brought it up first?
And
Judge Sotomayor.
Yeah, so especially by the female Justice Sotomayor, but bathrooms were not an issue in any of these three cases. And they were mentioned 42 times at oral argument. And the justices are kind of fixated on that. And unfortunately, specifically, the female justices got some heat for that after these oral arguments, particularly Justice Sotomayor, who said specifically some women feel, I think her words were, very intruded upon when someone that is transgender enters a women's bathroom, and what do we do about that? And Justice Gorsuch said, like Lake previewed, that, again, he's a conservative justice. Generally, conservative justices are textualists. They go with the literal meaning of the words instead of looking to interpret that meaning. And he did say something along the lines of, oh, it looks like you've got something here with the because of sex argument, but what about the massive upheaval, I think were his words, that would result? And that's not his job. His job is not to protect society from itself. His job is to interpret law. And so we're getting some signals from the court that make it really sort of up in the air as to what would a limited win look like and what would a wonderful result be. And I think a wonderful result, whether it comes from Congress or comes from the justices, would be to specifically find that there's absolutely no rational way to separate sexual orientation from sex. If you can't discriminate against your employee because she is a woman who has a child at home, and that's because of sex, then how can you discriminate against a female employee because, for example, she has a wife at home? It's not rational. And so actually finding that it's not and including that language would be the best win. And the same with the transgender case, and the issue there would be to actually include that word, just like Oregon has done, and decide that it's because of sex. And I don't think there's any other rational way to interpret it, but we're getting some strange signals about bathrooms and the like. So who knows what we'll get.
So it's clear there's uncertainty, and we will have time for Q&A for sure. So on the flip, a loss, and for the sake of time, let's just do kind of an all-out loss. What are the implications? There's folks here in the room, and we're in Oregon. So what are the implications? What does it mean? How can a layperson make sense of, wow, this is really bad news. What does this mean for me as an LGBT person?
Well, one thing that is somewhat concerning is that people may not know exactly what happened at the Supreme Court. A smaller employer in a smaller town, or even in Portland. And they may hear that the Supreme Court did not rule in favor of gay and trans people, and they may not realize that there is an Oregon law that is as broad, right? I mean, if there's a big win, then that affects everyone all over the country. We're all protected no matter where we are. But in Oregon, nothing really changes. Nobody brings federal claims in Oregon anyway. We're not relying on this for legal claims, but for the overall culture and how we're treating workers, how we're treating each other, how we're respecting each other, how we're recognizing the fundamental human dignity of workers and people within our community. If the highest court in the land is saying, and maybe they have a point that Congress, if they really wanted to do this, then they would make a law that says it specifically. Maybe that's a legitimate argument. The loss is more energy to lobby our congresspeople, but all of our congresspeople in Oregon would support it anyway. So, it's supporting other candidates in other states, sending your money elsewhere. I don't know how it really affects us here, a huge loss, other than that people might be confused and feel that there is a new license to discriminate against employees. Your employer may not know. You may have people who have employers that don't understand. So I guess that's maybe my thought about the concern.
That's really helpful. And I want to kind of go back to Nick on this one. So a loss happens. We're in a great state. There's protections. Kaiser is great. Even in Georgia, there's protections there. What happens as an employer, and I think this could be relatable for business owners in the room, if an everyday employee is like, haha, I read this in the paper and now it's my chance to discriminate. I'm a manager, I have some power. Like, what are companies like Kaiser doing, just to be very clear? We operate in these states, these are the state laws, this is our workplace policy.
I'm actually going to bring comparison of religious accommodations to the table. So given the law, federal law for religious accommodations for employees, say a nurse is treating a patient. The patient discloses they are gay. The nurse says, whoa, hold up, I can't do that. It's against my religion. What happens? The member does not know. They never know. So the patient's care still goes on. So this nurse has to go and alert their supervisor. And because they have protections that say, I have a religious belief that I cannot provide this care, and we have to abide by that law, they go to their supervisor, say, I can't do this. Someone else comes in and completes the encounter and provides the care for the patient. As the gay person, do I think that's entirely awesome? No. But we do have these laws that we still have to abide by, even when those beliefs may be contrary to our personal identities. And so in that case, the patient's experience goes uninterrupted. They are not to know that this is the reason that their care changed mid-encounter, and they will still have a satisfactory experience. The person whose religious beliefs prevent them from having that care are then sent on to do other things with their day, and so we remain in compliance in that case. So this is a long story short to say the answer is complex in these situations. Larger employers are going to abide by their company policies and by the states in which they operate. So I can only speak for Kaiser generally and say that Kaiser as an employer is going to abide by policies which do have it written, explicitly to include gender identity, sexual orientation in all of the company policies. So no matter where Kaiser operates, they will abide by those policies.
I think that's really helpful. And this kind of last section before we open it up for Q&A is really for PABA members, for small business owners and community around what more could we be doing in our own businesses to really send out a signal, this is a great state to be in, here's our company policy, we want the best and brightest to come and work here. I wanted to ask Lake and Gloria, since you all are both small business owners yourselves, and regardless of how many people you employ or not, what are some of the things that you might be doing right now just to kind of underscore your commitment, even if it's this influence in community, to kind of talk about, why this matters to you and kind of educating other business owners that might not know about these cases enough and how they could put out a positive message as well for LGBT folks in the state who might be a little nervous about the decision?
Well, I think one of the things I do is, because my law firm serves a specific population, which is the LGBTQ population, I have a lot of other lawyers that call me with their own questions about, honestly, they're sometimes about employment and sometimes about how to treat their clients or related issues. And so I try to spend as much time as I can having those conversations and just helping people understand what their obligations are and how I run my own business. I try to keep abreast of how the law is changing. So, there are Supreme Court cases, and those are really big and important. But as Lake was saying, big losses certainly would impact us, and I'm sure would impact morale. But there are a lot of protections in Oregon that would still be in place for Oregon workers. But there are also local changes, and I made a couple of notes about things that I had just looked into in the past few months. There's a House bill in Oregon that specifically clarifies that for purposes of state disability discrimination and accommodation, sexual orientation is not a physical or mental impairment. It sort of seems obvious, but when employers are navigating these issues, and especially non-lawyers, it can feel very tedious. An employer might even think that they are doing the right thing by calling something medical leave, and whether it is actually that or not might be a legal question. And so, trying to just sort of stay abreast of the way that the law is changing, even in our state, and even though it's in a positive direction, it's important to sort of keep tabs on it. And there was a Senate bill also, these are both 2019 new laws, there's a Senate bill last fall that made it unlawful employment practice for an employer to enter into a settlement, separation, or severance agreement that would prevent employees from disclosing or discussing conduct that constitutes unlawful discrimination, including sexual assault. And I think that one's really important. I had a case a few years ago where a teacher of a local private high school at St. Mary's Academy was fired because she was gay, and there was an enormous initiative to promote settlement in which she wouldn't be able to talk about what happened to her. And that's very common. That's really common for employers to call what I think some plaintiffs' attorneys like me call sort of gag orders, and to say you can't talk about this anywhere in any context. And that's just as problematic, maybe if not even more so, after such a difficult legal battle as what we were talking about earlier, which is just having the strength and stamina and ability really to carry forth a case like this. Because it's not only about personal strength, it's also about, people are thinking, how will I be employed in this town again if employers know that I've sued or brought a complaint or filed a complaint with the Bureau of Labor and Investigation about the things that have happened to me. So sort of just keeping abreast and making sure other employers, to the extent that I advise informally my friends and colleagues that do this work as well.
That's great. And Lake, thoughts on
Same.
that? Okay. All right. Great. Nick, I have a question for you on this, which is, and I'm not sure if you mentioned this in your introduction. So you're on the LGBT Employee Resource Group for all of, maybe just in Oregon, I'm not sure, but you're involved with the LGBT ERG, and I'm wondering, are there conversations inside a large employer like Kaiser right now around, okay, this is trending, this is a concern for us. Are there conversations there that you're thinking, maybe we can do some education inside of our company to talk with other folks about why this matters? Or
Well, talking about the SCOTUS ruling in particular, I would say among the pride groups in general, yes, but as a healthcare organization, the ruling itself is not Kaiser's bread and butter, if that makes sense. So what we would talk about, has Kaiser filed amicus briefings in support of LGBTQIA plus cases? Absolutely. Has Kaiser as an organization contributed to progressive causes? Absolutely. Does Kaiser have trans-inclusive training for employees? Yes. Are there bias trainings embedded at the manager level and above? Yes. So speaking to this particular ruling, no, but in general as an employer.
Yeah, and thank you for that. I think my not so articulate question was more for LGBT workers who might be concerned. Could there be activities just to allay those concerns, right?
Yeah, absolutely. And, I certainly say that the Pride group itself is very active, the Northwest region, which is basically Eugene to Longview, and then on other regions as well. And then, talks like educational opportunities do arise in scope of that. So
yeah, and thank you. So this is my last question for all of you, and maybe you want to pass or not. But before we open it up for Q&A, do you have any guidance for the LGBT business community, our allies in the room, around what more we could do as small business owners to just kind of get this information out? And in particular for those businesses that do business with other businesses in some of the 28 states that lack these protections right now. So education, or I don't know, putting something up on the website of "We welcome everyone" or something maybe more robust than that.
So just something that I think we haven't necessarily explicitly mentioned today is the impact of race on gender identity and sexual orientation, and when those two things intersect. And acknowledging that I'm white and I'm perceiving as a white passing panel here tonight. So when we talk about bringing people to the table, yes, it's a great first step to have that poster that says, "We welcome everybody. Sexism, racism, ageism, ableism, any ism is not tolerated." But you do also have to do your work and actively outreach to communities, to individuals, be embedded, show up. I'd say those are the things that are really going to help bring that word home and help know people that they are held and know that there are resources available for them.
Excellent. Any other thoughts?
Yeah, first I just want to say thanks for bringing up race. I think it's really important, and indeed I skipped over it, and it's just another facet that we need to be thinking of, one that we should be thinking of all the time. I think, it may seem obvious, but some of the things I think of are just, like you said, being embedded and getting out there, join boards. I think that's one way for entrepreneurs that probably have a lot of time on their hands or not. But I think it's one way to bring your knowledge and skill set and open-mindedness and really spread it around to other people who are in positions of power, and to include people with diversity factors, whether it is LGBTQ. And just as a note, I usually start off by saying I use the term LGBTQ plus, but certainly it is LGBTQIA plus, and probably other pluses that I'm not even thinking of, and I don't mean to be any kind of exclusionary, just to shorten the language so I'm a little bit less tongue-tied. But no matter what the diversity status or factors are, to make sure that you have a diverse set of employees, or that you are trying to promote diversity in whatever context you can. One of the things that I do that is also lawyer work, but not paid work and not board work, is that I sit on the Multnomah County Judicial Screening Committee, and I know that one of the judges in Multnomah County, and in fact a succession of several presiding judges in Multnomah County, they have been fairly open to and prioritizing the idea of procedural justice and having a bench of judges that reflects the diversity of the community. So I think part of the work that you can do as entrepreneurs is not only in your own businesses, because I sort of make the assumption that if you're here and you're queer or you're an ally, that you're being kind and you're giving people the benefit of the doubt and the most protection that you can, even if your business has fewer than 15 employees. But it's also to get out there into other parts of social and professional life, and to share your open-mindedness and knowledge about these topics with people who might just not have it on their radars, for better, for worse, or intentionally or not.
Okay, this is really, really good content here. I want to open it up for folks in the audience. If there, show of hands, question. I know, Michael, there's a question in the back, so we'll get to you. Other folks that may have a question, and you can think about it. I'm just going to bring the mic back.
Hi, well, thanks for being here, and thanks for all your great work. I feel weird talking on mic because we're not that far away, but it's totally fine.
I've felt weird about it all evening, too.
I'm wondering about the whole religious freedom defense, which is bullshit, because people say, I can hate because of my religion or God is against what you're doing. All those, like the cake cases and the pizza cases and all those. So what I'm wondering with these cases, if is the defense primarily that they're a private employer? Is it that they have a problem with it because of their religion? And do you think the court will look at all these other cases? So I know that this case is different because it brings in the 1964 Civil Rights Act, but I'm also thinking that they would at least look at these other cases and say that religious argument is not a strong enough argument to overshadow the civil rights portion, that your civil rights is more important than somebody else's religion. But then again, we have a special court right now. So I guess my question is what is the defense of these three cases? Is it that they're a private employer, or is it religion, or is it both?
I can speak to the funeral home case and the transgender case, and I'm not sure about the other two. I don't recall seeing that argument, but it may very well have been part of the case. But the owner of the Harris Funeral Home did argue that his religious belief prevented him from continuing to employ Amy Stevens. But in what I read, that seemed to fall by the wayside pretty quickly. That argument failed in the appellate court, I think, and the civil rights claim is the one moving forward into the Supreme Court. So I'm not sure. I know that, I'm not a RFRA expert in terms of religious protections, but I have litigated the issue to some extent. And I know one thing that I have always looked for and have found to be interestingly problematic for a couple of the defendants in my cases, but I've never got to actually try the issue, is just that religious belief has to be bona fide and truly held. And I think sometimes that is a difficult hurdle, particularly for employers or corporations as opposed to individuals. So for example, if you have a Catholic school that says, we can't employ someone who is gay because the archdiocese controls us, and they say no, that sort of begs the question, well, do you have a bona fide belief that you can't employ this person because of a righteously held religious belief, or because you're under the control of some other corporation? So there's a little bit of wiggle room to look at with those claims, but I'm not sure how they're playing out right now in these SCOTUS cases.
I actually don't think that the RFRA, which is Religious Freedom Restoration Act, which is an act that says that certain religious beliefs can overcome some laws, and there was a famous one related to the use of peyote or ayahuasca. And so, it was illegal to use these drugs, but if you're using them as part of a bona fide religious practice, then then those laws cannot be used to prosecute you for using and possessing certain drugs. And that has sort of morphed into what a lot of people see as a defense to discriminate, and a way that you can get around discriminating. I am not seeing, in what I've read and the briefs I've looked at with these particular cases, that being at issue. And I did listen to the oral arguments, and that wasn't something that came up. So with regard to this particular topic here today, that's not really, their defense is that in 1964, they were not thinking about gay and transgender people. That's really the thrust of it. And that if Congress wants to do that, they certainly have the ability to do that. They've done it before. But then also sexual harassment was not considered sex discrimination either until RBG made the point. So we have interpreted this word sex to mean more than what was on the minds of the legislators in 1963 and 1964. Is it going to extend to transgender and gay and lesbian people? That's really the question.
So it's more so they're arguing that they're not a protected class versus putting forth a strong defense of their own.
Well, the defense is that the statute that these people are bringing a claim under does not apply to them. That sexual orientation and gender identity are a separate category that is not in the language of the statute, and that Congress had no intent to protect these people. And if it did, it knows how to use words to be specific. Just look at Oregon. They did it.
Yeah, I think that also they're not feeling the pressure to explain themselves, right? It's just the argument is it doesn't count. It's not part of the definition, period. What we did was fine.
And a couple of times Congress was brought up. So how many folks have heard of the Equality Act? Okay, awesome. All right, so regardless of whatever decision happens, we have some great senators and if you're in Portland, a good representative who stands behind that bill. So just really making sure, if you haven't said this is really good, we're in a great state and we want to extend this to our neighbors, those 28 states that don't have these protections, and in particular in the workplace, along with other areas of life, to really support that. So that is one way where we have some power, and obviously, like, as business owners, you have influence, so that's important, in particular if you do business in other states that lack these protections. So before we wrap it up, I just want to see any final comments, questions, before we get to mingle and have fun. Well, thank you all so much for coming out. Let's give our panelists a warm round of applause. I know I learned a lot, and I hope everyone here did as well. So enjoy yourselves, and definitely, if you're not on the PABA mailing list and you like these kind of educational events, be sure to sign up, and hopefully we'll see you at our next education forum. So thanks again for coming out. Appreciate it.